We continue to read and study and discuss the divorce case between Mr. Vincent Guthrie and Dorretta, Mrs. Dorretta Guthrie. The law. The claimant, that's Mr. Guthrie, submits that by virtue of Section 4 of the Act, the equitable principles, such as the various trusts resulting, and constructive, as well as the common intention of the parties, play no part in considering the interests of disputing spouses in property. This is on the basis that that section provides as follows. Quote, the provisions of this act shall have effect in place of the rules and presumptions of the common law and of equity to the extent that they apply to the transactions between spouses in respect of property, and in cases for which provision is made by this act, between spouses and each of them and third parties, end of quote. In this regard, as he noted above, the claimant relies upon Section 14 of the Act to ground his claim. The introductory words of Section 4 are, or Section 14 are, where under Section 13 a spouse applies to the court for a division of property. This seems to me to indicate that consideration of the provisions set out in Section 14 apply where Section 13 applies. Section 13 is in the following terms. Section 13, subsection 1. A spouse shall be entitled to apply to the court for a division of property. A. On the grant of a decree of dissolution of a marriage or termination of cohabitation, or B. On the grounds of a decree of nullity of marriage, or C. Where a husband and wife have separated and there is no reasonable likelihood of reconciliation, or where one spouse is endangering the property or seriously diminishing its value by gross mismanagement or by willful or reckless dissipation of property or earnings. Okay, so these are the three main conditions under which a spouse may apply for a division of property. That there is a decree of dissolution, the marriage has been dissolved, or the term cohabitation for 5 years or more have ceased, or the nullity of the marriage, or where there is separation and no reasonably likelihood of reconciliation. But it also says, or where one spouse is endangering the property due to mismanagement. So this last part seems to apply even if the spouses have not been separated. But it's just that one of them is willfully mismanaging the property. Alright. An application under Section 1AB or C shall be made within 12 months of the dissolution of marriage, termination of cohabitation, annulment of marriage, or separation. So So you have 12 months within which to make such an application, even though the court might consider a longer period, because it says, or such longer period as the court may allow for hearing the applicant. All right. A claim of for division of property under section 14 therefore arises when that claim is made pursuant to section 13. Fulfilling the requirements of section 13 must therefore be a condition pertinent to an application under section 14. If that view is correct, and I have no doubt that it is, this is the judge discussing it, then it would appear that unless this action is brought within 12 months of the named circumstances set out in section 13 subsection 1 A to C, then no application can proceed under section 14 without the court having extended the time to bring such action. So that means the court allowing the action to be brought after 12 months has passed. In this case, there does not appear to have been any such application or agreement to extend the time for bringing the action under the relevant provisions of the Act. So, the couple did not make such an application for the time to be extended. In such circumstances, the claim proceeds in the normal basis as contained in the law of equity and law of trust. It is now settled, and the case of Stack versus Dowden, 2007, and Abbott versus Abbott, the Privy Council appeal of 2005, that where property is held in the joint names of two parties, the burden is on the person who asserts that the interests are to be treated other than 50-50 to show why this should be so. So there's again the 50-50 rule, and the burden is on the person who wishes to disrupt that rule to show why it should be. In a judgment I delivered the 24th of April 2009, that was O'Connor versus Shearer and another. In 2005, HVC 21 and 2769 of 2005, admittedly dealing with the family home in considering the issue of the share of interest in property held in joint names. I explored the decision of Stack, Abbott and Fowler versus Barron 2008. Referring to the decision in the Stack case, I stated the following. Alright, was the same judge. The statement of the judge. Baroness Hale's leading judgment in their lordship's house is a tour de force of analytical reasoning, tracing and analyzing the case law and historical development in this area of the law. She stated her starting points in these cases in the following terms at paragraph 58. Just before we read the statement at paragraph 58, I paused and looked up the meaning of tour de force. It says here, it is a performance or achievement that has been accomplished with great or managed with great skill. Alright? an achievement accomplished with great skill. Okay, the statement. Just as the starting point where there is sole legal ownership is sole beneficial ownership. The starting point where there is joint legal ownership is joint beneficial ownership. The onus is upon the person seeking to show that the beneficial ownership is different from the legal ownership. So, in sole ownership cases, it is upon the non-owner to show that he has any interest at all. So, where you alone own something, somebody else who doesn't own it, claiming interest, the onus is on them to show that they have interest in your property that you own. Okay, continue. In joint ownership cases, it is upon the joint owner who claims to have other than a joint beneficial interest. So if you and your spouse jointly own something and you want to claim that you have an interest in all or most of it, the onus is on you to prove that that is so. Okay. Continue. In delivering her judgment at paragraph 58 of the report, she said, the issue as it has been framed before us is whether a conveyance into joint names indicates only that each party is intended to have some beneficial interest, but says nothing about the nature and extent of that beneficial interest, or whether a conveyance into joint names establishes a prima facie evidence of joint and equal beneficial interest until the contrary is shown. So, the prima facie case, the assumption here is that when you and your spouse jointly own something, a property, on the face of it, it is 50-50, equal beneficial interest. But you know, if you do not agree with that, the onus is on you to show the contrary. Okay, we continue. For the reasons already stated, at least in the domestic consumer context, a conveyance into joint names indicates both legal and beneficial joint tenancy, unless and until the contrary is proved. Okay. And at paragraph 68, she said, the burden will therefore be on the person seeking to show that the parties did intend their beneficial interest to be different from their legal interests, and in what way. This is not a task to be lightly embarked upon. Lord Walker of Gestingthorpe, in agreeing with Lady Hale, said, I am in full agreement with the observation in paragraph 68 of Lady Hale's opinion, which I take to be of central importance to her reasoning and conclusions, that in cases where a house or flat has been registered in the joint names of a married or cohabitating couple, but with no express declaration of trust, there will be a considerable burden on whichever of them asserts that their beneficial interests are unequal and do not follow the law. So here the law says 50-50, but if you are saying you own 60, 70, whatever interest in the house, then the burden is upon you to state it. But of course, there are provisions in the Property Rights of Spouses Act to modify the 50-50 rule. As we have seen, which I have read the entire Right of Spouses Act in another playlist, but we continue here. So even apart from the intention which I have found above to have existed, I would hold that the claimant has failed to discharge the burden now placed on him by the authorities cited above. So the judge is saying that Mr. Guthrie has failed in his effort to prove that he has sole interest in one of the properties and a 60% interest in the other property. I hold that the evidence discloses that the parties always share a common intention to acquire property jointly for their joint benefit. In that regard, I accept the evidence of the defendant, that's Mrs. Guthrie, set out in his first affidavit that it was a common principle in our marriage that all our resources were to be applied to joint acquisitions for the promotion of the union and the family of the union. She also contradicts the claimant's averment that Shoebury, the first property allegedly purchased between them, was purchased with his own sole resources, and states further that the proceeds from the sale of that property was used to purchase Pickliny or Pit Kellini. Indeed, the affidavit of the claimant, Mr. Guthrie, tends to support this as it speaks of an intention to acquire property, quote, for the purpose of building a home for my family, end of quote. I should also note, so here, this statement for the purpose of building a home for my family. This is saying then that there is beneficial interest for both of them in that property. Right. I should also note that the defendant also asserts that, and this is not denied by the claimant, so Mrs. Guthrie asserts, make this assertion, and is not denied by Mr. Guthrie, that a part of the land at Sheffield had been sold by Mr. Guthrie, and she had not benefited from the proceeds thereof. In respect of the property at Hopewell, in which Mr. Guthrie claims a 100% interest, Mrs. Guthrie states that they both purchased the property from our joint resources. She points specifically to a sum of $325,000 paid to G. Mafesanti and drawn from their joint account at the Bank of Nova Scotia in Negril, Westmoreland. This, she says, was the deposit for the land at Hopewell. The defendant, Mr. Guthrie, also rejects the averment that the defendant, Mrs. Guthrie, also rejects the averment that she had nothing to do with the construction of the intended home at Pickliny, as she often made purchases or made payments to the workmen, as well as providing them with food. So Mr. Guthrie is saying that Mrs. Guthrie did not make any contribution to the building of that home, but Mrs. Guthrie is saying that she did because she made payments to the workmen and provided them with food. Based upon the evidence I have accepted, I hold that the property at Orchid Gardens, Hopewell, Hanover, registered at volume 1313, folio 733, is held as a 50% interest each by both the claimant and defendant. We will continue reading this case in the next video.